Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Scott Nelson, the defendant in this case, has been accused of the crimes of first-degree murder with a weapon, kidnapping with intent to inflict bodily harm or terrorize with a weapon, carjacking with a deadly weapon, and robbery with a deadly weapon. In this case, Scott Nelson is accused of first-degree murder with a weapon. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Jennifer Fulford was killed by Scott Nelson, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Scott Nelson may be found guilty of first-degree murder with a weapon or any lesser included crime. There are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. If you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1. Jennifer Fulford is dead. 2. The death was caused by the criminal act of Scott Nelson. 3. There was a premeditated killing of Jennifer Fulford. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1. Jennifer Fulford is dead. 2. While engaged in the commission of kidnapping with intent to inflict bodily harm, carjacking, or robbery, Scott Nelson caused the death of Jennifer Fulford. 3. Scott Nelson was the person who actually killed Jennifer Fulford. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. The crimes of kidnapping with intent to inflict bodily harm, carjacking, and robbery are all defined for you below under Count 3, kidnapping with intent to inflict bodily harm, Count 4, carjacking, and Count 5, robbery. If you find that Scott Nelson committed either first-degree premeditated murder or first-degree felony murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Scott Nelson committed either first-degree premeditated murder or first-degree felony murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of first-degree murder. When parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that the identity of the deceased in this case is Jennifer Fulford. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed first-degree murder with a weapon, the crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser-included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser-included crime. The lesser crimes indicated in the definition of first-degree murder with a weapon are second-degree murder with a weapon, second-degree murder, manslaughter with a weapon, and manslaughter. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Jennifer Fulford is dead. 2. The death was caused by the criminal act of Scott Nelson. 3. There was an unlawful killing of Jennifer Fulford by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Jennifer Fulford is dead. 2. Scott Nelson intentionally committed an act or acts that caused the death of Jennifer Fulford, or the death of Jennifer Fulford was caused by the culpable negligence of Scott Nelson. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find that Scott Nelson committed the lesser included offense of second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon or manslaughter with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Scott Nelson committed the lesser included offense of second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. To prove the crime of kidnapping, the state must prove the following three elements beyond a reasonable doubt. 1. Scott Nelson forcibly, secretly, or by threat, confined, abducted, or imprisoned Jennifer Fulford against her will. 2. Scott Nelson had no lawful authority to do so. 3. Scott Nelson acted with intent to inflict bodily harm upon or to terrorize Jennifer Fulford. Secretly means the defendant intended to isolate or insulate Jennifer Fulford from meaningful contact or meaningful communication with the public. If you find that Scott Nelson committed the crime of kidnapping, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of kidnapping with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Scott Nelson committed the crime of kidnapping, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of kidnapping. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the crime of kidnapping with a weapon, there may be evidence that he committed other acts that would constitute a lesser-included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser-included crime. The lesser crimes indicated in the definition of kidnapping with a weapon are false imprisonment with a weapon and false imprisonment. To prove the crime of false imprisonment, the state must prove the following two elements beyond a reasonable doubt. 1. Scott Nelson forcibly, secretly, or by threat, confined, abducted, imprisoned, or restrained Jennifer Fulford against her will. 2. Scott Nelson had no lawful authority to do so. Secretly means the defendant intended to isolate or insulate Jennifer Fulford from meaningful contact or meaningful communication with the public. If you find that Scott Nelson committed the lesser-included offense of false imprisonment, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of false imprisonment with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Scott Nelson committed the lesser-included offense of false imprisonment, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of false imprisonment. To prove the crime of carjacking, the state must prove the following three elements beyond a reasonable doubt. 1. Scott Nelson took a motor vehicle from the person or custody of Jennifer Fulford. 2. Force, violence, assault, or putting in fear was used in the course of the taking. 3. The taking was with the intent to temporarily or permanently deprive Jennifer Fulford of her right to the motor vehicle or any benefit from it. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state, used to transport persons or property, and propelled by power other than muscular power, but the term does not include traction engines, road rollers, personal delivery devices, special mobile equipment, vehicles that run only upon a track, bicycles, swamp buggies, or mopeds. An assault is defined as an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred before, during, or after the taking of the motor vehicle, and that the act and the taking of the motor vehicle constitute a continuous series of acts or events. If you find that the taking of the motor vehicle occurred as an afterthought to the use of force or violence, or the threat of force or violence used against Jennifer Fulford, the taking does not constitute carjacking, but may still constitute grand theft motor vehicle. In order for the taking of the motor vehicle to be carjacking, it is not necessary that the person carjacked be the owner of the motor vehicle. It is sufficient if the person has custody of the motor vehicle at the time of the offense. The taking must be by the use of force or violence, or by assault so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require that a victim of carjacking resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be carjacking, it is not necessary that the taking be from the person of a victim. It is sufficient if the motor vehicle taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against a victim. If you find the defendant guilty of the crime of carjacking, you must further determine beyond a reasonable doubt if, in the course of committing the carjacking, the defendant carried a deadly weapon. An act is in the course of committing the carjacking if it occurs in an attempt to commit carjacking or in flight after the attempt or commission. If you find that the defendant carried a deadly weapon in the course of committing the carjacking, you should find him guilty of carjacking with a deadly weapon. A weapon is defined to mean any object that could be used to cause death or inflict serious bodily harm. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried no deadly weapon in the course of committing the carjacking, but did commit the carjacking, you should find him guilty only of carjacking. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the crime of carjacking with a deadly weapon, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of carjacking is grand theft of a motor vehicle. To prove the crime of grand theft of a motor vehicle, the state must prove the following two elements beyond a reasonable doubt. 1. Scott Nelson knowingly and unlawfully obtained or used or endeavored to obtain or to use the motor vehicle of Jennifer Fulford. 2. He did so with intent to, either temporarily or permanently, deprive Jennifer Fulford of her right to the property or any benefit from it, or to appropriate the property of Jennifer Fulford to his own use or to the use of any person not entitled to it. Obtains or uses means any manner of A. Taking or exercising control over property. B. Making any unauthorized use, disposition, or transfer of property. C. Obtaining property by fraud, willful misrepresentation of a future act, or false promise. D. Conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining money or property by false pretenses, fraud, deception, or any other conduct similar in nature. Endeavor means to attempt or try. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. 1. Scott Nelson took U.S. currency from the person or custody of Jennifer Fulford. 2. Force, violence, assault, or putting in fear was used in the course of the taking. 3. The property taken was of some value. 4. The taking was with the intent to permanently or temporarily deprive Jennifer Fulford of her right to the property or any benefit from it, or to appropriate the property of Jennifer Fulford to his own use or to the use of any person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. If you find that the taking of property occurred as an afterthought to the use of force or violence or the threat of force or violence against Jennifer Fulford, the taking does not constitute robbery robbery, but may still constitute theft. In order for a taking of property to be robbery, it is not necessary that the person robbed be the owner of the property. It is sufficient if the person has the custody of the property at the time of the offense. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed at a victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant carried a knife or duct tape in the course of committing the robbery and that the knife or duct tape was a deadly weapon, you should find him guilty of robbery with a deadly weapon. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that the defendant carried no weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the crime of robbery with a deadly weapon, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of robbery is petty theft. To prove the crime of petty theft, the state must prove the following two elements beyond a reasonable doubt. 1. Scott Nelson knowingly and unlawfully obtained or used or endeavored to obtain or use the property of Jennifer Fulford. He did so with intent to, either temporarily or permanently, deprive Jennifer Fulford of her right to the property or any benefit from it, or to appropriate the property of Jennifer Fulford to his own use or to the use of any person not entitled to it. Obtains or uses means any manner of A. Taking or exercising control over property. B. Making any unauthorized use, disposition, or transfer of property. C. Obtaining property by fraud, willful misrepresentation of a future act, or false promise. D. Conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. Property means anything of value and includes real property, including things growing on, affixed to, and found in land, tangible or intangible personal property, including rights, privileges, interests, and claims. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed. The defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 7. Has the witness been convicted of a felony? Whether the statement met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1. Whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. The jury is not to discuss any questions the jurors wrote that was or were not asked by the court and must not hold that against either party. And ladies and gentlemen of the jury, you're going to get written copies of this instructions. There was a typographical error on what I just read to you. That's my initials and my scratch through on that. 8. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. And members of the jury, as I indicated, the written copy of the instructions on the law will be sent back with you, and what I'm holding up is also what will be sent back with you. These are the verdict forms. And at the top is just the caption of the case. Below that, it has verdict, in parentheses, count one. Below that is a line next to the statement that says, we, the jury, find the defendant guilty of first-degree murder with a weapon as charged in the indictment. Below that, there's a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of first-degree murder. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder with a weapon. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder. Below that, there's a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of manslaughter with a weapon. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of manslaughter. Below that, a line next to the statement that says, we, the jury, find the defendant not guilty. Below that, so say we all. Below that, dated Orlando, Orange County, Florida, on this blank date of June 2019, a space to fill in the date, a signature line for the foreperson. This is the second verdict form, ladies and gentlemen. And again, just the caption of the case. Below that, the word verdict. Below that, in parentheses, count three. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of kidnapping with intent to inflict bodily harm or terrorize with a weapon as charged in the indictment. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of kidnapping with intent to inflict bodily harm or terrorize. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of false imprisonment with a weapon. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of false imprisonment. Below that, a line next to the statement that says, we, the jury, find the defendant not guilty. Below that, so say we all. And below that, dated Orlando, Orange County, Florida, on this blank day of June 2019. Again, space to fill in the date, signature line for the foreperson. Members of the jury, this is the next verdict form. Again, caption of the case. Again, below that, the word verdict. And below that, in parentheses, count four. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of carjacking with a deadly weapon as charged in the indictment. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of carjacking. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of grand theft of a motor vehicle. And below that, a line next to the statement that says, we, the jury, find the defendant not guilty. Below that, so say we all. Below that, dated Orlando, Orange County, Florida, on this blank day of June 2019. Again, space to fill in the date, signature line for the foreperson. And members of the jury, the last verdict form, again, caption of the case. Below that, the word verdict. Below that, it says, in parentheses, count five. And below that, a line next to the statement that says, we, the jury, find the defendant guilty of robbery with a deadly weapon as charged in the indictment. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of robbery with a weapon. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of robbery. Below that, a line next to the statement that says, we, the jury, find the defendant guilty of the lesser included offense of petty theft. And below that, a line next to the statement that says, we, the jury, find the defendant not guilty. Below that, so say we all. and below that, dated at Orlando, Orange County, Florida, on this blank day of June 2019. Again, space to fill in the date and signature line for the foreperson. If you return a verdict of guilty of the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions and in writing orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of the exhibits will be sent into the jury room with you when you begin to deliberate. However, exhibits that contain biohazardous materials or weapons cannot be sent into the jury room. If you wish to see any exhibits that are not sent into the jury room, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Can counsel please approach? All right, members of the jury. Count 2 has been removed from your consideration. You will note, as I indicated, the verdict forms instructions will be sent back with you. You will notice there's no reference to a count 2. That is the reason. Count 2 has been removed from your consideration. In addition, as I indicated, the instructions, verdict forms will go back with you. Certain of the evidence is going back with you. Among the evidence going back with you are evidence of audio files and or video files. In addition, there is a laptop that will be going back with you that's been agreed to by the parties that does not have internet access. Of course, you're still under the court's instructions not to be accessing the internet regarding this case, but this computer does not have internet access. However, it's being provided because it will allow you to examine the audio files and video files to the extent you wish to do so. So that will also be sent back with you. And in a moment, I am going to send you back into the jury room. Juror 94, you could just raise your hand, okay, and Juror 310, and Juror 75. All right. Y'all aren't in trouble, but I need to speak with you briefly when the others go back into the jury room. Again, you're not in trouble, you haven't done anything wrong, but I do need to speak with you briefly when the others go back. With respect to the rest of you, at this time, you may take your notepads and your pens with you and go with the deputy into the jury room to begin your deliberations. All right, Juror 94, Juror 310, and Juror 75. I know that each one of you would make an outstanding contribution during the deliberation process. I know that all of you have been very attentive. However, under Florida law, only 12 jurors are permitted into the jury room during the deliberations, and that's why they have been excused and you've been asked to remain. I cannot allow you to actually participate at this time during the jury deliberation process. I do know if there is going to be another phase to this trial, as we discussed during our jury selection. In a moment, I will be excusing you from the courtroom, but you will remain under all of the court's instructions, including the instructions not to have discussions with anyone regarding this case and not to read or listen to any reports about this case. If the second phase is necessary, I am ordering you to I am ordering you to return to participate in the second phase of the trial. As I indicated, we don't know at this time whether that will be necessary. However, at this time, the penalty phase, if necessary, will commence on Monday, July 1st, 2019 at 9 a.m. So I am going to order you to return to court on Monday, July 1st at 9 a.m. because we may not have the ability to contact you over the weekend to ensure that you arrive. So I have to give you the order to come back Monday, July 1st, 9 a.m. I am directing you to, on a piece of paper, put your juror number and put 2 contact phone numbers for you. If something changes, meaning you don't need to report on July 1st at 9 a.m., we will make every effort that we can to contact you in advance to avoid you unnecessarily coming to the courthouse on Monday. But at this time, I'm ordering you to come back to the courthouse, follow the deputy's instructions as to where you need to be, what time you need to be there, so that we can start the phase 2, the penalty phase, if necessary, at 9 a.m. on Monday. So make sure you give the deputies that piece of paper with your juror number and 2 contact numbers on it. Again, I remind you, you remain under the order of the court. You cannot discuss the case with anyone. You cannot read or listen to any reports about this case. No one is allowed to contact you concerning this case. On behalf of the citizens of the Ninth Judicial Circuit, I thank you very much for your service. I'm very happy that all 12 jurors remained healthy and were able to participate. But we can't see the future, and you never know if something would have arisen where one of those 12 jurors would have had to be excused for an unforeseen reason. If we would not had you serving as well, a mistrial would have had to been declared and the entire process would have had to start over. So again, at this time or in a moment, I am going to excuse you from the courtroom. You are still a member of this jury. You are still under the instructions of the court to not read, listen to any reports or in any way discuss this case amongst yourselves or with anyone else. Your notes are going to be collected. They will be stored in the event we have the second phase, as I previously mentioned to you. If we do not conduct the second phase, they will be destroyed, as I previously told you. You did order your lunch. You need to talk with your deputies on your way out when you're giving them the piece of paper with your juror number and your 2 contact numbers. Once your lunch has arrived, you're free to take that with you and enjoy the rest of your day. But again, you remain under all the court's instructions and enjoy your weekend. We will see you Monday, July 1st, 2019, 9 a.m. Follow the deputy's instructions as to where you need to be. And again, leave your notepads and your pens on the seat. Oh, and you also have some mugs from the clerk's office for your service. The deputies will also give you that as you leave. All right, so at this time, again, just leave your notepads and your pens on your seats. Enjoy the rest of your day. Again, thank you for your service. We'll see you on Monday. All right, if the attorneys can just give a last check here of the evidence, the instructions that I read to the jury and the verdict forms I'm giving to Madam Clerk, that'll be included with the exhibits that are going back with the jury. Mr. Nunnally and Ms. Moore. I just hand wrote, as I had done with the defense motion, that before I said the defense make all necessary arrangements, but the state make all necessary arrangements. All right? Mm-hmm.